My name is David Friedman. I'm counsel here at Wagner Sidlofsky and co-chair for this Lunch and Learn seminar series together with my colleague Peter Neufeld, and we will be discussing family and estate law. Can I say from the outset, if you would ask, may I ask you to please mute your microphone at all times unless you're asking questions at the end of the presentations, and then I'd ask you to mute yourself again. And the other thing I'd like to remind you is that this is being recorded. So the topic that we are discussing today is litigating separation under Section 43.1 of the Succession Law Reform Act. A paper was prepared by Adam Wygodny, Peter Neufeld, and Sarah Strathopolous in advance of today's seminar, and a link to that paper will be found in the Zoom chat shortly, together with a certificate of attendance that you can download. So we have three speakers today. Two of my colleagues at Wagner Sidlofsky, Adam Wygodny and Peter Neufeld. Both Adam and Peter practice in the area of estate litigation as well as commercial litigation. We also have with us Sarah Strathopolous, who I hadn't met until today, but I did look at her bio at Epstein Cole, and she's a very impressive lady. She practices family law and is a partner with Epstein Cole. She's a graduate of the University of Waterloo and Carleton and the University of Ottawa, and was the recipient of the Patrick D. Schmidt Future of Family Law Award for 2022, awarded by the Advocate Society, and has been active in a range of CLA programs dedicated to family law. And I'm very happy that Sarah has chosen to participate in our seminar today with us. I'd like to thank our sponsors, Scotia Wealth Management, Brith, Epstein Cole, Concentra Trust, BMO Private Wealth, TD, Torkin Mains, Solus Trust, and WeirFoulds. This event is complimentary due to the generosity of our sponsors. If you enjoy our seminar, even if you don't enjoy our seminar, we'd ask you to consider making a donation to the B'nai Brith Canada Food Program if you haven't done that already. And a link for that is in the chat. I understand that Elite Mannheim, the manager of legal affairs at B'nai Brith, is here with us today and can tell us a bit about that organization and its charitable work. Elite, are you here?
Yes, I am. Thank you.
Over to you.
Thank you so much. So good afternoon. My name is Elite Aronson Mannheim, and I'm the manager of the Legal Affairs Department at B'nai Brith Canada. For those of you who do not know B'nai Brith is Canada's oldest human rights organization. We are a principal grassroots voice dedicated to eradicating racism, anti-Semitism, and hatred in all its forms. We champion the rights of the marginalized and provide basic human needs for members of our elderly community. That's why we maintain a food bank here in B'nai Brith, in which we give every week a box of food for all the seniors in our community that are in need of such. We also provide them with programs to ensure their activity, such as gym, or of course everything is provided and is suitable for their age. We also have clothing runs, which we open and collect for and provide not only to B'nai Brith community or the Jewish community, but rather all communities in need. We have pop-up shops that throughout the year. It's although it's called shop, there's no money exchange. We just give it away. B'nai Brith Canada is recognized as a vital voice in promoting Jewish unity and continuity. a staunch defender of the State of Israel and global jury, a tireless advocate on behalf of senior citizens, and a leader in combating anti-Semitism and racism. Our support comes from thousands of Canadian families with diverse backgrounds and interests that empower the organization to speak to government, to media, and to public at large on issues of concern to the Jewish community. Since 1982, Bnei Brith has also produced an annual audit of anti-Semitic incidents that have served as the authoritative document on the existence of anti-Semitism in Canada. The audit was actually launched yesterday, both in print and online format. It is still circulating in the news, so you may have a chance to hear about it. The audit reflects the number of anti-Semitic incidents reported to and monitored by our League of Human Rights, including through our anti-hate app, anti-hate hotline, report an incident webpage, as well as data collected from law enforcement agencies and other sources. Unfortunately, as you may all know, on October 7, 2023, the world changed following an unprecedented and coordinated armed incursion by Hamas against innocent Israeli civilians. At least 44 countries denounced the attack as terrorism. The day was labeled the bloodiest in Israel's history and the deadliest for Jews since the Holocaust. The widespread global increase in anti-Semitism that followed had been horrifying and an increased fear in Jews all over the world. Our audit, which was made public yesterday, recorded 5,791 anti-Semitic incidents in 2023, a jump of almost 109% from 2022. Violent incidents went up by 208%. Harassment went up by 124%, and online anti-Semitism incident increased by 135.7%. On average, you can say that 16 anti-Semitic incidents occurred every day. Bnei Brith will continue to monitor and give support to all those encountering anti-Semitism in hopes for a peaceful future. Thank you.
Thank you very much. So let us now begin our program in earnest. Adam, I believe that you're going to be speaking to us first. Is that right?
Yes, thank you, David. So today we're going to be looking at section 43.1 of the Succession Law Reform Act. Before we look at the actual text of the statute or the provision, I thought it might be worth taking a look at the Hansard from the debates as to what the government intended to achieve by enacting this provision. So at the second reading of the bill, Robert Bailey said, under these proposed reforms, an inheritance to married spouses who are separated would also be eliminated in the same way that divorced spouses do not inherit. It's a bit of another strange rule, but if you officially get divorced, then it's understood you probably didn't mean for your will that you made when you were married to apply, so your will automatically doesn't apply. But if you are separated and never actually got divorced, or you were never married and separate, there is no way the will changes. I know reading this, I'm thinking of a case back in my riding where this happened to an individual. He fully intended for a young lady who he raised as his daughter to inherit the bulk of his estate. He never changed his will. He died. The new wife and her children got most of the bulk of the estate. The girl who he raised was, and I quote, SOL, I guess for want of another word. This change will help to ensure that when someone passes away, their assets are going to go to the people that they truly intended them to go to. That is why we're extending Section 17 of the Succession Law Reform Act. And I will say that the language that we're looking at in Section 43.1 of the Succession Law Reform Act also appears in Section 17. And then at the third reading of the bill, Lindsay Park said, we clarified with the amendment that you have to be separated for a 3-year period immediately preceding the death in order for this section to apply. That's just because we heard from some stakeholders that there might have been confusion on the interpretation of the 3-year period. If someone had had a separation earlier on in their marriage, if you added up the different periods of separation, might add up to 3 years. And someone might not realize they had approached this 3-year period before they passed away. So we thought that was an important clarification. So now what does section 43(1) say? Well, subsection 1 says any provision in this part that provides for the entitlement of a person's spouse to any of the person's property does not apply with respect to the spouse if the spouses are separated at the time of the person's death as determined under subsection 2. Subsection 2 reads, a spouse is considered to be separate from the deceased person at the time of the person's death for the purposes of subsection 1 if A, before the person's death, 1, they lived separate and apart, and as a result of the breakdown of their marriage for a period of 3 years, if the period immediately preceded the death. 2, they entered into an agreement that is a valid separation agreement under Part 4 of the Family Law Act. 3, a court made an order with respect to their rights and obligations in the settlement of their affairs arising from the breakdown of their marriage. Or 4, a family arbitration award was made under the Arbitration Act 1991 with respect to their rights and obligations in the settlement of their affairs arising from the breakdown of their marriage. And B, at the time of the person's death, they were living separate and apart as a result of the breakdown of their marriage. I'm going to ignore the transition provision for today. And looking at section 43(1), we see that for it to apply, 1, the spouses must be living separate and apart. The separation is, quote, as a result of the breakdown of their marriage. 3, they lived separately for the 3-year period immediately preceding the death. And 4, at the time of the death, they were living separate and apart as a result of the breakdown in their marriage. Now, we can compare this provision with Section 8 of the Divorce Act, which provides, 1, a court of competent jurisdiction may, on an application by either or both spouses, grant a divorce to the spouse or spouses on the ground that there had been a breakdown of their marriage. 2, breakdown of a marriage is established only if A, the spouses have lived separate and apart for at least 1 year immediately preceding the determination of the divorce proceeding, and were living separate and apart at the commencement of the proceeding, or B, the spouse against whom the divorce proceeding is brought has, since the celebration of the marriage, 1, committed adultery, or 2, treated the other spouse with physical or mental cruelty of such a kind as to render intolerable the continued cohabitation of the spouses. 3, for the purposes of paragraph 2A, spouses shall be deemed to have lived separate and apart for any period during which they lived apart, and either of them had the intention to live separate and apart from the other, and B, a period during which the spouses have lived separate and apart shall not be considered to have been interrupted or terminated, 1, by reason only that either spouse has become incapable of forming or having an intention to continue to live separate and apart, or of continuing to live separate and apart of the spouse's own volition, if it appears to the court that the separation would probably have continued if the spouse had not become so incapable, or 2, by reason only that the spouses have resumed cohabitation during a period of, or periods totaling not more than 90 days, with a reconciliation as its primary purpose. And I would point out that what appears to be significant is that the Divorce Act specifies the circumstances to establish the breakdown of the marriage, as well as what it means to have lived separate and apart. And it also includes provisions that provides for attempted reconciliations, all of which appear to are absent from section 43.1. Now that said, I'll turn it over to Sarah to begin further discussion.
Okay, thank you. So from a family law perspective, the date of separation is an important date for us for a variety of reasons. It's what crystallizes the value of property for property division, and it's what starts the clock on cases where somebody has a support right or entitlement, and it also starts the clock on the ability of the court to grant a divorce. So, not unsurprisingly, arguments over whether the parties, when they separated, whether they've been living separate and apart for a period of time or just separated, it can be in a lot of cases a hotly debated topic. One of the reasons for that can be strategic in that there is limitation periods for being able to seek certain claims, and so people may seek to backdate or alter depending on when they proceed to court, but there's a variety of reasons. One would think that the question of when the parties separated would be relatively close in terms of, I have a file right now where we're arguing over whether they separated in August or October of the same year. One would think that there would be a more closeness in terms of the date. One of my partners recently just settled a trial on the eve of the trial where the date of separation was over a decade apart. And so there are very differing views of when the parties separate. So from the family law perspective, while I want to be able to give you a succinct answer that the court will tie it up in a bow and say they separated or they're not separated, it's not. What the court has done has spent a lot of time looking at many cases where this issue has been argued and has provided us with a succinct framework of what objective factors could be applied within the different cases. But how those are applied to each case is subjective and unique to that specific fact pattern and how that family lived their lives. And so there is no hard and fast answer, and there is a nuanced application of the facts. So I will talk to you a little bit about what those objective factors are that the court looks for. And then I will give you a little bit of, highlights of what type of evidence people put forward, so that as the estate bar, when you're looking to answer this question, you have a little bit of guidance on what we use to show to support arguments on the date of separation. I would flag before I get into that one other thing that I think is interesting, that when you look at your section 43.1, the legislation specifically carves out valid separation agreements, which obviously makes sense to me, because if the parties have entered into a separation agreement, the standard separation agreement contains full and final estate releases. So I can understand why they indicated the separation agreement. One thing that I would tell you to look for that might not have in here or isn't specifically listed in the Succession Law Reform Act is marriage contracts. So in our marriage contracts, we specifically include in them that they're a domestic contract, but they are not necessarily a separation agreement. However, they often include a clause that says, and cohabitation agreements, sorry. So cohabitation agreements contain a clause that says if married, it becomes a marriage contract, and the marriage contract clause and cohabitation would say something that along the lines of, in the event of a separation, this will automatically become a separation agreement. Older agreements may not have that language, whereas newer ones tend to have it. But we include in those agreements, if there is a case of separate as to property or waivers of property rights or waivers of estate rights, those would be included in a marriage contract. So I would flag to look for that. And also in the marriage contracts, we include almost as a matter of course, a definition of what a breakdown of marriage means. And it is somewhat different than what Adam spoke to you about under the Divorce Act. So the Divorce Act is a breakdown of the marriage as a result of living separate and apart for a year, or as a result of affairs or domestic violence. Both of those have to be going a step further in that after that conduct, there is the intention to separate as well. And in the Family Law Act, when we look at valuing property for the purposes of property division, we don't call it the date of separation, we call it the valuation date, okay, which can be somewhat different than the date of separation if parties separate and then there's muddled reconciliation, but it's the valuation is the date we value property. And the definition of that, and this is in the paper, is the earlier of 5 dates. And there's the date of divorce, the date of annulment, the date of death, but one of them is the date that the parties live separate and apart with no prospect of resuming cohabitation. In our marriage contracts and other agreements like that, we write the breakdown of the marriage is the earliest of, and this is in line with section 43, the date at which the parties separated with no reasonable prospect of resuming cohabitation, or 2, the date in which the parties give notice in writing of an intention to live separate and apart and subsequently demonstrate his or her actions in that regard. And then there's the more common divorce, annulment, or death. I have started as a matter of course, putting a little bit of extra language in those agreements that for greater certainty, the breakdown of the marriage, and this is specifically applicable probably in a lot of estate cases where a breakdown of the marriage and will not be deemed to have occurred because the parties are living separate and apart because one has been institutionalized in a hospital, retirement home, or simply because somebody has become what I don't know the proper language you use, but it may become have lack of capacity because of health reasons. So with all those definitions, it all comes down to the concept of there's a breakdown of the marriage because they're living in separate and apart, and there has to be an intention. So that is a main underlying factor in family law, is that the breakdown of the marriage and the reasons the parties are living separate and apart has to be an intention for there to be a breakdown or an end to the marriage. And again, we look at objective factors and then we apply them to the unique realities of a relationship. And that's important given that there's various ways of structuring different relationships, whether it's cultural, social. We have to have an eye on the nuanced elements of that. So again, when you look at the paper, there's the what would be one of the most leading cases is the Oswell case, where the court really highlights 6 factors that the court will look at. At Schedule A of the paper, we included an excerpt from a 2019 case of Al-Sajji, which is lengthy, but it provides a broadened overview of how the Oswell factors have been interpreted by cases since then, and expands them. So when I'm talking about the factors now, I'm going to be kind of amalgamating my discussion of the primary ones that Oswell looked at, and then the expanded ones that the case law has looked at since. So the first one, again, is living separate and apart when there's an intention. So the separate and apart does not mean in 2 separate homes. It's a physical separation, but it's not a physical separation necessarily in 2 areas. It's a separation where the conjugal relationship has come to an end. When I say that the issue is somewhat complicated, I say that because people can live separate and apart in the same home. And they can move into different bedrooms, different parts of the homes. They can stay in the same room, but just opposite sides of the bed, and they sleep at night. But they can also there can also not be a breakdown of the relationship where people live in separate homes. So there are cases where marriages, people are in separate homes, or after a difficulty in the marriage, sometimes people separate and reside in separate properties, but are still working on the marriage, going to marriage counseling, still intimate with each other, still going to things, and it's just a matter of a different configuration. So the separation is the breakdown of the conjugal loving relationship, and physical separation in that regard, but not necessarily in two separate homes. There has to be an intention to end what is considered the marital relationship. So that's both the intimate aspect of it, but also the social aspect of it. And so we often look at changes in the dynamics in the home, changes in who completes certain tasks, domestic responsibilities, how the financials are structured, and things like that. One important thing for the family law perspective is there certainly does not need to be an agreement on this. There does not need to be meeting of the minds. One person doesn't need to say the marriage is over and the other one say, I agree. It can be triggered. A breakdown of the marriage and living separate and apart can be triggered. The starting of that clock can be triggered by one person making the decision and then taking the step to act in accordance with it. We all know that the breakdown of relationships are not as clean as everything is great one day and then there's one day when it's over. There's a slow breakdown in a lot of relationships where there's a lot of heated arguments. And so simply saying it's over and on a Wednesday and then attending marriage contract on a marriage counseling on a Friday and muddling through for a couple more months might not be sufficient, but saying it's over and then moving into the spare bedroom and stopping the communal meals and telling people that may be sufficient. So it is a statement or a decision with an unequivocal conduct that follows. In terms of illustrating what has been done. And we look at the true intention and not the stated intention because of being able to manipulate limitation periods and dates at which we value property depending on what's happening in the real estate markets and the stock markets and things like that. The date of it can be important. So the court also looks at things like ongoing sexual relations, but the absence of that is not determinative, and the continuation of that is also not determinative. So it is a very holistic view of all the different circumstances. And Adam spoke about how the Divorce Act gives spouses 90 days to attempt reconciliation without resetting the date of separation. And so discussion of reconciliation, if there's no act to try to reconcile, might not be enough to reset the date of separation. And sometimes people will try to reconcile a few times, reset what we deal with as the date of separation, and it's ultimately the final one that the courts will look at. So when we look, if you look at the Schedule A, it gives you a lot. I think there is 26 different factors or principles that Justice Chappell pulled out of all the different cases that have looked at the Oswald principles and really expanded it. And gives you kind of a hint of what the court would look at: daily routines, spending special occasions together, buying gifts, extended family obligations, vacations together. Those are the more nuanced ones, in addition to the bigger ones of ending conjugal relations and physically being separate and apart. When you look at how we deal with this in the court and proving it to the court, in the family law context, it can be done in a couple of different ways. If it's done on a preliminary motion, or if it's raised, it can be done by affidavit, with the court now wanting to make trials more succinct. They do a preliminary affidavit, or it's done by somebody sitting on the stand and actually giving their view of the story. So there is the oral evidence or written evidence aspect of it, that is somebody's narrative of when the dynamics changed and how they changed. And then there's the secondary aspect of it, of actual documentary proof that we use. So when we're looking at document evidence, we look for things like tax returns when people change their marital status to separated. We look at text message and email communications between spouses, which is getting more and more common, where they actually physically write their intent at the time. We look at things like property designations, if property is transferred or purchased, and whether or not, or remortgaged, and you have to check the box of whether you have a legal spouse anymore. One of my partners recently had one where beyond looking at things like addresses on driver's license and things like that, she had a gun license and a fishing license, which apparently you also have to check off in those, whether you have a legal spouse at the time. And then there's the more subjective things we look at. Are anniversary cards still exchanged? What do they say? Family photos, marriage counseling appointments, activity on dating apps, evidence of new relationships, looking for new accommodations, rental, lease agreements, changes to beneficiary designations on wills, investments, RSPs, that kind of thing, credit card and bank statements showing changes of spending patterns, division of those accounts, redirecting employment income, emails, applications for new crediting, opening new accounts where you don't necessarily have to specify that you have a spouse. Those are things that you can point to a document where somebody made a statement about the status of their relationship. And then you have the more subjective evidence that will come out of, when the people were last intimate, whether they're in separate rooms, whether they stopped doing meals together, whether they stopped doing communal laundry, communal grocery shopping, when they stopped attending family functions, when they told family members that the relationship was over, when they stopped going on family trips together. Some of those can be a little bit, again, more nuanced if they have children and the parents continue to do some of those social attendances or outings together with the children to maintain some type of stability, where we have parents that can be amicable. But there is no hard and fast one factor that's determinative. The court will look at these long lists of objective factors and then weighing the credibility of it, of the person and the of their evidence, to make a determination as to which date, if the parties are putting forward two separate dates, is more likely the date of separation. And to make it even more complicated, the case law even says you don't have to pick between one of the two dates put forward by the party. It could be another date that the court thinks the evidence points to. And so those principles will start to help you in the estate bar looking at the question of separate and apart. I don't envy that you also have the challenge of only having that information coming from one side. And so the deceased estate, I'm assuming, would be the one that would argue that they were separate and apart. And so you'll have the challenge of finding that evidence and figuring out who will put forward that evidence. In cases where you don't have you don't have the spouse that can speak to it. Adam, I'll switch it back over to you unless you have any questions that you want me to elaborate on now.
I can jump in now. Thank you, Sarah. That's really helpful, really informative, and it kind of makes you, appreciate that when you're representing your client and you're trying to argue what the date of separation is or the valuation date, and you're trying to show that either they were separate and apart or they weren't, that you're really going to have to go outside your own interpretation of what a marriage is to you. And you're going to need to look at those Oswald factors to kind of give a good objective understanding of, to say, okay, well, maybe this marriage doesn't look the same way. Maybe they live in a different socioeconomic situation or cultural or religious situation than I do, but it's still very much a marriage. And just because they, may not look like they're together all the time, that's not going to fly. That's not going to mean that they're separate and apart, and they should, be disentitled from someone's estate as a result. I'm going to talk a little bit about some of the unique situations that we might have in estate litigation that you don't see as often in the family law context. Of course, I only know the estate litigation side more than I do the family law side. One thing I was thinking of was, okay, breakdown of a marriage is really important for determining whether a spouse is going to be disentitled from their deceased spouse's estate. So why didn't the court just go ahead, or the legislature just go ahead and define what breakdown of marriage means in the Succession Law Reform Act? They did that with the family law, or with respect to a spouse. They refer to the Family Law Act. And there's a couple definitions of spouses depending on where you are in the Succession Law Reform Act. So why didn't you just do that for the Succession Law Reform Act for a breakdown of marriage? And I think the answer to that is, well, it's actually kind of an awkward definition to input. Keep in mind, the point of the definition of breakdown in a marriage in a divorce act is to get divorced. You need to figure out, is there an actual breakdown so I can properly, receive an order divorcing my spouse? And that's not always going to work in this context when you're determining whether someone should be disentitled from their spouse's estate. So I'll give you an example. One of the main situations that we see for when there could be a breakdown of a marriage is when someone has been separate and apart since commencing an application. They've been separate and apart for a year. But in the case of section 43.1, you need to be separated for 3 years as a result of a breakdown in a marriage. So one of the first questions I thought to myself was, well, hold on, is it actually 3 years that you're separate, or is it 3 years after a breakdown? So is it 3 years plus 1? I think the answer to that is a quick no. I think that the wording of the Succession Law Reform Act is that they're living separate and apart as a result of a breakdown in a marriage. And so I think that the number is still going to be 3 years, not 4 years. But that's certainly something to consider. But then really, what's the point of including, the breakdown of a marriage language if you're already going to have to be separate for 3 years? If divorce, you need to have a breakdown of a marriage in situations where you're separate for at least 1 year. But with section 43.1, you need to be separate as a result of a breakdown of a marriage for 3 years. Well, then the question is, well, why didn't you just say separate and apart for 3 years? Why did you have to say as a result of a breakdown of a marriage? And in my view is that this term breakdown of a marriage was included because the legislature really wants you to refer to section 8.3a of the Divorce Act and the family law jurisprudence. So section 8.3a talks about, for the purposes of section 2a, so for the purposes of determining whether there's been a breakdown of a marriage and whether they've been living separate and apart, the spouses will be deemed to have lived separate and apart for any period in which they've lived apart and either of them had the intention to live separate and apart from the other. So it's really that importance of the emphasis of intention that Sarah's already discussed, that we need to make sure that, yeah, you've been separate for 3 years, but you've actually had an intention to live separate and apart for 3 years. And so I think that's why, they make reference to the breakdown of a marriage, because they want to look at the Oswald factors. They want to look at that section 8.3a, as opposed to, maybe that's more important than whatever section 8.1 of the Divorce Act, considering what they define as a breakdown of a marriage. I think the carve-outs in that definition are more important. That kind of takes me to my second point, which is, what are some of the unique circumstances you're going to see in estate litigation, whether where former spouses or spouses are living separate and apart as a result of this breakdown of a marriage? And I think the most obvious one is people who are moving to care homes or retirement homes. And the two could be very, very different. Certainly, you're going to have that in the family law context, but by the nature of estate litigation, you're going to see that more in these estate litigation matters. So again, that's why I say, section 3, I think it's section 3B1, Roman numeral I, or Roman numeral 1 of the Divorce Act is really important here. That shows that to have the intention to live separate and apart, it can't just be because you have to live separate and apart and you don't have a choice, right? And that's really important for when you're thinking about a long-term care home. Just because someone's been in a long-term care home for over 3 years, that's not going to be enough to say that they should therefore be disentitled because they've had to live separate lives. The same goes for a hospital. If you have serious medical treatment and you're confined to a hospital outside of the home, away from your spouse, I think the legislature is clear enough. I think the act is clear enough that you're not going to be able to say that, you're now disentitled from, or someone's disentitled from their estate, from their spouse's estate, just because they had to be in a hospital or a long-term care home. But it gets complicated, right? A retirement home may not be the same thing as, well, it certainly isn't the same thing. And there's a spectrum to the degree of care that you receive in retirement homes and in long-term care homes. And so, I think people are going to have to grapple with that issue to consider, okay, well, what was the type of care that they were actually receiving at this institution? And do they actually truly need to live there? Or was this merely an alternative to living at the home with their spouse because they no longer wanted to live there? On that note, we might start to see these applications under Section 43.1 to be used to combat dependent support applications. I'm not saying you're going to see that all the time. I think it might be a niche situation, but Sarah mentioned that you could live in the same house, but still be living separate and apart. So consider a situation where spouses have, possibly decided that they don't really want to be together anymore. But they don't want to live elsewhere. One of the spouses is paying for the rent or the mortgage on the home. The other one's living there, but otherwise they're living their own separate lives. Well, under Part 5 of the Succession Law Reform Act, maybe you'd be able to say that you're still financially dependent on your spouse and you'd be able to seek dependent support, but that may be met with opposition from a disgruntled beneficiary, maybe a stepchild, saying that, no, you haven't lived together really for the last 10 years, and you shouldn't be entitled to any portion of the estate or the intestacy. So I think those are situations that are really helpful to, consider when this is going to be, litigated eventually quite a bit more in estate matters. We haven't seen it yet. I think there was one case that we referred to in our small paper that, again, referenced Section 43.1, but hasn't actually delved into the merits of it. So we're very excited to see where we go from here. On that note, it's 12:46 right now. I think I'll open the floor to questions, unless Sarah or Adam, you have anything else you'd like to include.
And you can just turn on your camera and your mic to ask a question, or if you prefer, you can type your question into the chat bar and I'll read it out. So there's a question in the chat bar from Charles. For Sarah, can you summarize impact of data of separation under the FLA, where there's a reasonable prospect that the spouses will resume cohabitation? For estate litigators, SLRA does not mention reasonable prospect that spouses will resume cohabitation as a factor. It is a factor for Section 43.1. So Sarah, can you address that point?
So in terms of the question of whether they've separated without a prospect of resuming cohabitation, this is the gray area of whether there is in fact a date of separation or evaluation date. So I mentioned this earlier, there are cases where the breakdown of the relationship might be a little more slow and painful than other cases where the parties waft in and out of periods of high conflict, where words are said where they've separated and then things cool and they are, not quite ready to make a decision. They haven't contacted lawyers. Neither of them have said necessarily or started to act as if the marriage is over, and they muddle through for a period of time. They try marriage counseling or those kind of things. So when you look at the Oswell factors and then the factors that are set out in Schedule A in more detail, those are the factors that will lead to the question of whether there is in fact the intention that we're looking for to actually permanently end the relationship, as opposed to just conveying a dissatisfaction with the relationship but not actually making any attempts to act differently. So you would look at those factors. If somebody said this is over but continued on the next day in the same type of domestic relationship, the same type of intimate relationship, didn't make any changes to the financials, didn't tell anybody that it was over, that would not be significant enough to trigger the breakdown or to say that there is no reasonable prospect of resuming the relationship. And so that or reconciling. So that is what we're looking for when we're muddling through that period of time, when we're trying to interpret one spouse's conduct or the other as to whether they have actually formed the intention for there to be a permanent termination. And the other reason why that language is in there is because it works with the concept of the Divorce Act, in that sometimes people have separated and then there are periods where they're trying to figure out if or they're attempting reconciliation, but it doesn't cross over the 90 days to reset the date at which we would say there was a permanent breakdown of the relationship. And so the final date at which property is valued per the Family Law Act. The Family Law Act deals with the property division. The Divorce Act deals with the actual divorce, and then they both deal with spousal support. Although if you were divorcing, you would be dealing with spousal support under the Divorce Act as opposed to the Family Law Act. But that's the reason why, is because we're valuing properties and they don't want people to try to choose different dates for the purposes of valuing property based on what happens with the market. And so those factors are what you would look at to determine whether there has absolutely been a breakdown with no reasonable prospect of reconciliation.
Thank you very much. May I invite other participants to ask questions?
I have a question for the panel.
Go ahead.
If that's okay. So there's another part of the definition of breakdown in marriage while we're on the subject of the Divorce Act that I think it's section 8 sub 2b that triggers a breakdown of a marriage when there is adultery or physical or mental cruelty. So for applications under 43.1, is that part of the definition of the Divorce Act relevant for purposes of determining whether a separation has existed as a result of a breakdown of marriage?
It's a good question, and it kind of goes back to what I was mentioning, that, you know, really keep in mind the breakdown of a marriage definition in the Divorce Act is intended to divorce someone. So if you've been subject to physical or mental cruelty, or if you've been subject to an affair, then you should be able to divorce your spouse sooner than that 1 year period. That's I think why we have, you know, that part of the definition in the Divorce Act. I don't think it would, in the end, be relevant for purposes of determining whether there was a breakdown in the marriage for the Succession Law Reform Act. And I say that because, again, that second part of the definition focused on separation. Well, you're already going to have to be making that determination whether you're separate and apart for longer, for 3 years, not the 1 year. So it may be, you know, I certainly believe that it will be a factor for and would be, you know, information that may be included in an affidavit for determining whether the individuals intended to live separate and apart. It might give the court, you know, a bit of context as to why they say these spouses live separate and apart. But for actually meeting that threshold, I don't think that satisfies the threshold of showing that there is a breakdown in a marriage, just because I don't think it's actually relevant.
Thank you.
Thank you very much. Can I turn to a couple of questions that are in the chat bar? Bruce Young asks, for interstate situations, what factors would you look to determine if a companion is in fact a Part 5 spouse? So this is the definition of a spouse for the purposes of dependent support.
Okay, well, but keep in mind, so that's Part 5, and I think we're dealing with, is it Part 2 that deals with 43.1? Yeah, Part 2. So the definition of spouse is going to be different in that case. It will not be the same definition as that in Part 5, because Part 5 refers to, I think, Section 29 of the Family Law Act. You can look at the definition of spouse in the Succession Law Reform Act, and it says spouse, except in Part 5 of the SLRA, has the same meaning as in Section 1 of the Family Law Act. So you'd want to look to Section 1 of the Family Law Act to see if we're actually talking about spouses, if we meet that threshold.
Terrific, thank you. Another question. If there was a separation agreement earlier and 120 days before the death, the parties resume cohabitation, what's the result under section 43.1?
This is where the differences with the Divorce Act play in, because there's no provision in section 43.1 that contemplates an attempted reconciliation at any point. So, until we get a decision from a court interpreting the provision in those sort of circumstances, it's on a plain reading of the statute, they would not be considered separated and apart for the purpose of section 43.1, because they're now cohabitating again.
Perfect. Are there other questions?
I see that there's another, there's an addition to the previous question that was posed to me. If two adults who have been companions for many years, spend lots of time with each other, start residing together, what could be considered the point in time that they might be considered spouses? Well, because we're dealing with section 43.1, keep in mind the point of that provision is to create a circumstance where a spouse is no longer entitled to their intestate rights. The premise that's mentioned here, though, the idea of that they're companions, they spend lots of time together. If you're not married, you're not going to get the intestate rights. Or if you're not sort of next of kin in some situations. So I think the answer to that is, well, it's a bit of a red herring. It's not something that the courts are going to have to consider for a section 43.1 case because, although they may consider themselves spouses, if they're not going to be presumptively entitled to intestate rights, then there's no purpose to consider, you don't have to go to that step to say whether someone might construe them as being spouses. Under section 43.1, they have to be married.
Terrific. We've only got a couple of minutes left, so perhaps we can end the seminar. I just want to say a couple of things. One, you might be interested to know that the Uniform Law Conference of Canada is looking at the rights on an intestacy generally. It may very well be that the law is going to move to separate marriage and intestacies altogether, and marriage and inheritance rights. And I don't know where the law is going, obviously, on this, but I find it interesting that at one time, the rules respecting intestacies as well as other parts of the Succession Law Reform Act were based on what we thought people wanted, and we were capturing our expectation of intentions, and now it seems a bit more prescriptive rather than not. And so I think that's going to be continued changes to the succession law regime, especially with respect to the intersection of family law in the next few years. So just to finish things up, let me thank everyone for attending. There is a link in the chat bar to a certificate of attendance that you can download. Our next seminar is in 2 weeks' time, and the topic that we'll be looking at is setting aside domestic contracts post-mortem. And my colleague David Wagner will be speaking with Aaron Franks. If you haven't registered yet, you can do so at the link that is in the chat bar. And as a final reminder, the link to the B'nai Brith Canada Food Program can also be found in the chat bar in case you'd like to donate to this worthy cause. So once again, thank you all very much for attending, and we'll see you again in a couple of weeks.